ahead and release you in these probation matters on your own recognizance as well. Now, you do need to contact your probation officer within 72 hours of your release. If you, and you also need to go to those hearings, okay? All right, go ahead, step to the left, officers have your paperwork. All right, Luis Garcia, please, and then Bryson Dunham. Okay. All right, Mr. Garcia.
Just go over there and say. Oh my God.
All right, stop putting him right there, sir. All right, Mr. Garcia. Mr. Garcia, can you go ahead and state your name, please?
I can't speak to you. I don't want, nobody can hear it, sir. That's the whole thing.
He's requesting that the speaker is turned off so no one can.
I have one question for you, and that's it. After that, you can turn it back on.
Okay, no, sir, this is public proceeding, and I am going to keep it public. Go ahead, state your name, please.
No.
Sir, you do have the right to remain silent. Anything you say could be used against you. All right, I'm going to remind you.
But it's no criminal. None. I'm not. What I'm saying is, it has nothing to do with criminal. It has to do with my past from a different state.
Okay.
Which law enforcement that apprehended me told me to bring it up to your attention, and it was brought up to their attention as well. I don't know why they didn't bring it up to your attention.
Okay.
That's what I'm trying to talk to them about, because it's really important.
Okay.
And that was the whole thing why I'm going around like this. It's
Okay.
no, it's just so it's kind of just write it down. You can read it, and then you can go from there.
I am going to keep these proceedings public. Let's start with. Go ahead, state your name.
I'm not stating nothing. You know who I am, and that's just it.
Oh, okay. All right, officers have based upon the info. Did you fingerprint Mr. Garcia?
Yeah.
And is this Luis Garcia, whose date of birth is January 18th of 1982?
Yes, sir.
All right. I am finding, sir, that you are Luis Antonio Garcia, whose date of birth is January 18th of 1982. All right, Ms. Sauer, would you like to go ahead and make your appearance on behalf of the state?
Yes, Your Honor. Dawn Sauer on behalf of the state.
Thank you. All right, sir. You are here on a Superior Court new case. You were arrested on charges of murder in the second degree, a Class 1 felony, and 2 counts of possession of a weapon by a prohibited person, Class 4 felonies. Based on the information contained in the Form 4, I am inclined to find probable cause for both of those violations, but I am going to hear argument from the state if the state would like to make any on probable cause.
This time, Your Honor.
All right. And based on the information in the Form 4, I am finding probable cause for all of those charges. I am appointing you an attorney, and I am setting hearings on May 29th at 8:30, the status conference on May 29th at 8:30, and a preliminary hearing on June 2nd at 8:30, both in the downtown Maricopa County Superior Court. I must now consider and decide terms and conditions of release. In order to do that, I have reviewed the Form 4. The state has also submitted a written recommendation in this matter. The state is requesting a cash-only appearance bond in the amount of $1.5 million. In the event that's posted, they are further requesting electronic monitoring. Based upon the information in this case, including the relevant criminal history, I am of the opinion that I am inclined to believe that that is an appropriate bond. However, I'm going to hear argument from the state.
I don't have a criminal history in Arizona, so I don't understand what you're talking about criminal history unless you're talking about the one in California. That's totally different.
All right, Ms. Sauer, would you like to make argument?
Yes, Your Honor. The state does believe the $1.5 million cash only bond is appropriate based on the current charges. The defendant shot and killed the victim. He shot the victim multiple times. He fled the scene. His criminal history is highly relevant given that it includes convictions for attempted murder, kidnapping, robbery, carjacking. He's an extremely violent criminal and committed yet another violent offense. The state also believes he's a significant flight risk. Thank you.
Thank you. All right. Having heard argument from the state, I am going to go ahead and set a cash-only appearance bond in your matter in the amount of $1.5 million. In the event you are able to post that bond and secure your release, you would be subject to certain pretrial release conditions, including electronic monitoring. You're not to return to the scene of the alleged crime or have any contact with any alleged complainants or witnesses. You are not to have any contact with any alleged you may not have any contact with the deceased person's next of kin or any person entitled to victims' rights in this case. You're not to possess any weapons, no drugs without a valid prescription, and no alcohol. All right, anything further from the state on this matter, Ms. Sauer?
No, Your Honor, thank you.
All right, sir, if you go ahead and have a seat, we'll get your
I have a
paperwork.
question.
Yes, sir.
The detectives asked me if I wanted my attorney present. I said yes. They went to give me the phone number, and at the end, they told me I wasn't allowed to talk to them. I didn't even get to see them. They just brought me here.
Okay.
I don't know. There was something else. You just asked this lady. I don't know what her name is.
So she is the state's attorney?
Is there any way I could get a reducer bail?
No. So based upon the information contained in the Form 4, as well as the criminal history in this matter, again, I believe that a high bond is appropriate. I think that the state's request is reasonable and appropriate in this case. All right. Go ahead and have a...
I have one last question.
Yes, sir.
They keep denying me from asking. Paper, pencil, please.
No, sir. I'm not gonna take a note. Go ahead,
I'm gonna answer you.
sir. You need to step back.
Hey,
You need to step back.
let's go. Let's go.
I'm not, no.
Let's go.
I got one question. This is important. The apprehension team told me to ask you. Let's go. Go. She's listening to me. There's been one question, man.
Okay, I will listen. One question.
Hold on.
You have to face forward, sir. If you're gonna ask.
Okay, the apprehension team told me that you know about California. They said that it's important for you to know, that about protected custody. And they said if you put me in that, I'm just good.
Okay.
But there was something that happened over there.
Okay, Ms. Sauer, Mr. Garcia is asking, about protective custody. Does the state have, information or a position on that?
Your Honor, I don't have any information as to whether that would be
Can you get a hold of
appropriate or not. I defer to the court's discretion.
Can you get a hold of the apprehensive team? They're the ones who did the research on me. They brought it up.
Okay. At this point, I am going to rely on detention officers to make sure everyone, including you, is safe. All right, so go ahead and detention officers will help you out.
Yes, sir.
So, like stuff, we are.
All right, Bryson Dunham, please.
One second.
Oh, I am so sorry. And officer, go ahead, take your time. I'm going to call on warrant. And out for us for just a minute. I'm going to call on a few warrants. Is that okay with you? Oh, okay. Because she was going to appear on number. Go ahead, get started, man. All right, Ms. Sauer, do we have you back?
Here, Your Honor.
All right, perfect. All right, Mr. Dunham, go ahead, state your name.
I am Bryson Dunham,
And Mr. Dunham, what is your date of birth?
August 11, 2006.
Thank you. All right, sir. And on behalf of the state, Ms. Sauer?
Dawn Sauer on behalf of the state, Your Honor.
All right, sir. You are here on a superior. Oh, thank you so much. All right, and on behalf of defendant, who do we have?
Good morning, Your Honor. Faisal Ullah appearing virtually on behalf of defendant Bryson Dunham.
Perfect. Thank you so much. All right, and Mr. Dunham, if I didn't do it before, I'm going to do it now. Can you state your date of birth, please?
August 11, 2006.
Thank you. All right, sir. You are here on a Superior Court new case. You were arrested on charges of 10 counts of sexual exploitation of a minor, class 2 felonies. Based upon the information contained in the Form 4, I am inclined to find probable cause for that violation. However, I am going to hear argument from the state, and then I'm going to hear argument from your attorney. All right, Ms. Sauer, would you like to make, would you like to make any argument on probable cause?
Not at this time, Your Honor, but I may have something to say after I hear from defense counsel.
All right, Mr. Ullah, do you have any argument on probable cause?
Judge, at this point, although the description of the files, in my view, is pretty thin, overall, given the nature of the case, I would just submit. I recognize there's likely going to be some changes as we go through the review and the charging process by the state. So at this moment, I'll just submit on PC.
Okay. All right. Based upon that, I am going to go ahead and find probable cause for those charges. Mr. Ullah, I am noting that based upon your notice of appearance, that is a limited notice of appearance for purposes of this initial appearance only. Is that still the case?
Yes, Your Honor.
All right. Then I am going to go ahead and appoint the public defender at this point to represent Mr. Dunham going forward. Although, again, Mr. Ullah, I am acknowledging that you are appearing for him at this initial appearance hearing. I am setting a status conference on May 29th at 8:30 and a preliminary hearing on June 2nd at 8:30. Both of those will be in the downtown Maricopa County Superior Court. I must now consider and decide conditions of release. In order to do that, I have reviewed the Form 4. I have also reviewed the state's written recommendation in this matter. The state is recommending a $150,000 cash-only appearance bond. But I'm also going to hear argument starting with the state, and then I'm going to hear argument from your attorney, Mr. Dunham. All right, Ms. Sauer, do you have any argument on conditions of release?
Yes, Your Honor. The state's requesting a $150,000 cash-only bond, and if posted, electronic monitoring, no internet, and no contact with minors. The materials that the defendant was in possession of are concerning. There were multiple files, but even more concerning are the defendant's admissions that he was seeking out this material, that he does feel sexually gratified when viewing material involving children. The state's concerned for the safety of the community, especially any children that he may come across. And given the amount of prison time that he's likely facing for this, the defendant does have incentive to flee. Thank you.
All right, thank you. All right, and Mr. Ullah, on behalf of Mr. Dunham.
Judge, I'm requesting the court consider the least onerous release condition in this case, which would be some form of pretrial services and statutorily required electronic monitoring. It is that type of a case that requires placement of electronic monitoring. I would just briefly note history of Bryson, and also then towards the end indicate reasons why I feel that that recommendation is more appropriate. Judge, we're dealing with someone who is 19, 20 years of age. I recognize that the Form 4 summary does indicate some admissions that are attributed to him, but and I understand we're not here to debate the facts, Judge, but it does appear to be that when Bryson made those admissions, he was not given the Miranda warnings as was necessary. And furthermore, it's only when he made those admissions, perhaps the officers engaged in the two-step process where they got what they wanted and then administered the Miranda warnings. And once he received those warnings, he then decided to invoke his right to remain silent. But I point that out only to indicate that the notion that this young man is a threat to anyone's safety or well-being was based upon his statements that, in my view, do appear to be suspect, especially given the apparent employ of the two-step process that the law enforcement officer engaged in trying to get him to admit to fit a narrative of their investigation. I also point that out, Judge, as an indication that this young man did cooperate with their investigation. This was back in January, Your Honor, when the police attempted to have contact with him, and he sat with them and answered their questions. And then just a day or so ago, we're on the 23rd now, but on the 21st, when the police reached out to us and indicated that they were going to arrest him and wanted us to bring him in, we also remained in complete compliance with them even at that time. Initially, the information was that law enforcement was going to give us a few days to bring him in. Later on, we find out that law enforcement is not available on Friday, Saturday, Sunday, and Monday. So we then scrambled to get him in, or excuse me, Saturday, Sunday, Monday, and Tuesday. So we scrambled to get him in Friday in the afternoon at 6 p.m. when we self-surrendered him at the station. That also is an indication, Your Honor, that this young man cooperated with the investigation and is not a flight risk. And this is not hyperbole, Judge. There is nothing in his background to indicate that he is a flight risk or he's a danger to anyone. He has no criminal history or any indication of negative law enforcement contact in his background that suggests to anyone that he might be criminally inclined. He just is not. I would also note, Your Honor, that he's a student. He's also employed. He resides with his parents, and he's wholly dependent upon his parents, Your Honor. They transport him to work. They transport him to his school. He does not have a driver's license. He is not in any way in a position where he poses any type of threat or danger to anybody. I would also note, Your Honor, that when the court looks at the metrics that are provided to the court in determining what the release conditions might be, we look at the failure to appear score, and we also look at the criminal activity score. And I couldn't help but notice, Your Honor, in reviewing the paperwork, that he scores at the very low end of both of those matrix. The failure to appear score is a 1, which is the lowest on a scale of 1 to 6, I believe. And the criminal activity score, Your Honor, is a 2 on a scale of 1 to 6, not because he has anything in his background to indicate that he is someone with character for criminal activity, but rather I suspect that it's just based on the nature of the charges that he's facing. But in spite of that, Your Honor, if the court looks at the recommendation from the pre-sentence assessment, it does appear that their final recommendation is an OR release even. Yet we are dealing with, I understand, charges that call for electronic monitoring. And I would submit that electronic monitoring as required by statute for a young man who's 19, 20 years of age, who's a student, who doesn't have any criminal history, who's also employed, who resides with family and reliant on parents for transport, Your Honor, would be a reasonable least onerous release condition that is contemplated by the rules. And under these circumstances, there is nothing to indicate that he's not going to show up to court. He is not going to cooperate in his defense. I recognize that the charges that he's facing, if it continues to be 10, if it continues to be something less than that, are of course prison mandatory. But of course, the court is not going to get too far afield with that because we run into concerns about his presumption of innocence. But I do recognize that that is a factor. But I would point out, Judge, that there is nothing in his background to suggest that he cannot be counted upon to follow the court's orders. If anything, Your Honor, I would submit that everything in his background indicates that he is the type of person who would comply with all lawful orders from this court or pretrial services, etc. Accordingly, I would respectfully request the court to consider that the release conditions be consistent with what is statutorily mandated, that is electronic monitoring. I would even invite a curfew, Your Honor, if the court feels that's appropriate. I would just request that the court allow him to be able to travel for his work, his school, and also for legal and medical appointments as are needed.
All right. I do appreciate your argument. Counsel also appreciated the argument of the state. Certainly, I do appreciate that Mr. Dunnan did self-surrender. I think that is significant. However, in these cases involving child sex crimes, I also consider the community safety, and the community is, of course, made up of children as well as other folks. In view of my concerns over the community safety, I am going to go ahead and set a secured appearance bond in this matter in the amount of $150,000. In the event Mr. Dunham is able to post that bond and secure his release, he would be subject to certain pretrial release conditions, including electronic monitoring. I'm also ordering no victim contact in this matter. And I'm ordering no contact with any minors. There are no exceptions to that. He may access the internet for work, court, and school purposes. He's not to possess or consume any drugs without a valid prescription, no alcohol, and no marijuana, THC, or CBD products without a valid prescription. All right, anything further from the state, Ms. Sauer?
No, Your Honor.
All right, anything further from you, Mr. Ula?
No, Judge.
Okay, all right, Ms. Sauer and Mr. Ula, I appreciate both of your appearances this morning. I know it's not the most convenient time for a lot of folks, so I do appreciate your appearances. All right, Mr. Dunham, could we print his order? If you go ahead and have a seat, sir, we'll get that brought out to you, okay? Yes, ma'am. All right, and Mr. Ula and Ms. Sauer, you should feel free to excuse yourselves whenever whenever is convenient for you.
Thank you, Your
Thank
Honor.
you.
All right, we do have 2 house calls this evening. Our first house call is number 9 and 10, Jose Osario. Mr. Osario is unable to be with us because he is combative. Our second house call is Kristen Ordonez. She is docket numbers 29 and 30. And she is unable to be with us because she is combative and a spitter. Based upon that information, I am finding that Ms. Ordonez and Mr. Osario are a danger to self or others. So I will conduct their initial appearance hearings at their cell. All right, Mr. Osario, is date of birth is 12/17 of 89. He is here on a Superior Court new case. He was arrested yesterday on charges of aggravated assault, a Class 3 felony, burglary in the 3rd degree, Class 4 felony, and criminal damage, a Class 1 misdemeanor. I did find probable cause for those. I am appointing him an attorney. I am setting hearings in his matter on May 29th at 8:30, May 29th at 1:30 p.m., and June 2nd at 8:30. All of those will be in the downtown Maricopa County Superior Court. Because Mr. Osario was on release in his case CR 2025-136556 on the date of offense for his new charges, I am holding him non-bondable on his new charges. Now, so let's talk about his 25 case. Mr. Osario is also here because the Maricopa County Superior Court issued a warrant for his arrest based upon his failure to appear in his case CR 136556. That matter deals with theft of a means of transportation. In that matter, the court should already have made a determination about whether or not he is entitled to have an attorney appointed for him. So I'm not making that decision again this morning. I am setting a hearing on May 27th at 8:30 in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in the amount of $1,750. All right, our last house call is Kristen Ordonez. Miss Ordonez is date of birth is August 8th of 77. Ms. Ordonez is here because the Maricopa County Superior Court issued warrants for her arrest based upon her failure to appear in her matter CR 2025-145402. That matter involves possession of dangerous drugs, possession of drug paraphernalia, and criminal trespass in the 3rd degree. Maricopa County Superior Court also issued warrants for her arrest based upon her failures to appear in her probation matter CR 2024-130661, CR 2024-154361, and CR 2024-146672. In each of those matters, the court, in all 4 of those matters, the court should already have made a determination about whether or not she is entitled to have an attorney appointed for her. So I'm not making that decision again this morning. In all 4 of those matters, I am setting a hearing on May 28th at 8:30 in the downtown Maricopa County Superior Court. In Ms. Ordonez's 25 case, I am setting a secured appearance bond in the amount of $2,000. In each of Ms. Ordonez's 324 probation cases, I am setting secured appearance bonds in the amount of $50. Anything changes after I talk to the house calls in-house, I will update my written orders in those cases. And that does, in fact, bring us to the end of our 2 a.m. initial appearance calendar. We are going to go ahead and stand adjourned until 5, and we are off the